Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. Today is 17 April 2026 years after Jesus. It is a Friday, and we're back in Baird versus Bonta on the constitutionality of open carry at the Ninth Circuit. Republican judges standing up for the Constitution. And I like it. It's styled as Mark Baird versus Rob Bonta. We are on page 27 of this PDF file, which reminds me, I probably should save this file at some point. Sometimes you can't find the PDF anymore. So always make sure you get a PDF. I like to print it out and make notes. So um, I would like to show you. I print it out and I make notes. I usually have a cigar or maybe a cup of coffee. It's a little bit early for a cigar right now. It's still technically in the morning, so I'm doing coffee. I'm definitely not a morning cigar guy. I'm not a coffee and cigar guy. I tried it once. As they say about the Holocaust, never again. Well, at least some people say that, um, like you're supposed to. But there are some major countries that don't say that at all. They say again. They say again. Thank God we have Republican presidents willing to stand up and do hard things for the sake of uh, righteousness and goodness in the world. Praise the Lord. Hallelujah. And this is a wonderful opinion. We've gotten through page 27 and we're right at Roman numeral V. It looks like a V, I know, for all you kids who don't remember the Roman Empire, but I'm old enough to remember the Roman Republic, not just the Roman Empire. So we're going with Roman numeral V, and we start. We next address Baird's as applied challenge and facial challenges to California's separate but equal rural licensing scheme. These challenges are easily disposed of. The district court dismissed Baird's as applied challenge to the rural licensing scheme for lack of standing because Baird failed to join local licensing authorities who could redress his injury. In his opening brief, Baird never contests the standing based dismissal of his as applied challenges to the rural licensing scheme. Because arguments rebutting the district court's standing analysis were not raised clearly and distinctly in Baird's opening brief, he has waived this as applied challenge. Let's take a look at footnote 17. Um, okay, I'll let you take a look at footnote 17. We're on page 28 at the top. To the extent that Baird facially challenged California's rural licensing scheme. His challenge runs counter to Bruin's indication that shall issue licensing regimes like the licensing that California allows in less populous counties can be constitutional. The court explained that nothing in its analysis should be interpreted to suggest the unconstitutionality of the 43 states shall issue licensing regime under which a general desire for self-defense is sufficient to obtain a permit. That's at Bruin, 597 U.S. at 39, note 9. At least on its face, California's rural licensing regime is a shall issue regime. Now, this is a key issue right here. Okay. This panel of judges, Republicans, yeah, are I just accidentally muted myself. I might as well mute myself. I need a drink of water. My mouth is a little bit dry from that coffee. I don't know what's going on with the coffee today. At least on its face, California's rural licensing scheme is a shall issue regime. He says on its face. This is an important thing to note about these judges. They can smell BS. It's great. It's great. I love this. He can smell BS. And you can see as we get into this, you can see that he's very good at sniffing out the BS of the Democrats here. So here we go. Sharing my screen. Feel free to call me Sharon. Okay. Bruin left open the possibility of as applied challenges to such licensing regimes, including Baird's arguments that California's rural licensing scheme does not operate as a shall issue regime in practice, but Baird's waiver of his as applied challenge to the rural licensing scheme means no such arguments remain in this case. Ordinarily, if this was a Democrat writing this and I read that, I'd be like, okay, he's going to lose. This is not a good sign because he waived. It's like, what can I say about standing here? You're normally not supposed to just waive a challenge. Let the court do the heavy lifting, okay? Let them do it. Don't give them a win. Just don't waive any challenge. Put it on the table, you know? Let the court decide which one they want to go with. Because when you waive a challenge, what you're basically doing is you're giving the Democrats a free pass, a free ride at Disneyland. But he waived his as applied challenge here on that issue. But check out Roman numeral VI, because it's coming, bub. It's coming. California's arguments in defense of its urban open carry ban are misdirected and fail in any event. What a line. What a next line. Contrary to California's suggested approach, Bruin's analogical approach does not permit loose analogizing against the backdrop of a clear historical practice. But even before we get to that, most of the state's brief incorrectly asserts that Baird is only challenging a licensing regime, and the rest of its brief is predominantly dedicated to refuting the argument that the Second Amendment prohibits licensing requirements. Now that is a major F up on California's part. The Democrats are clearly grade inflated here. They're hiring attorneys. No wonder they want to constantly lower the requirements for law school and lower the requirements for the bar. I mean, it's the Democrats that want to do that are behind all that grade inflation in law school. Let me take a sip of coffee. I just sorry, my coffee's still hot. I gotta drink it while it's hot. Hold on. I didn't want you to have to listen to me slurping my coffee. Just look at this. Look at this. Man, California's arguments in defense of its urban open carry ban are misdirected and fail in any event. They can't even defend an urban open carry ban. This is how bad the Democrats have gotten. Contrary to California's suggested approach, Bruin's analogical approach does not permit loose analogizing against the backdrop of a clear historical practice. But even before we get to that, most of the state's brief incorrectly asserts this is, guys, this is like can you ride, not even can you ride a bike, it's can you ride a tricycle. Incorrectly asserts that Baird is only challenging a licensing regime and the rest of its brief. So in other words, they didn't even read what he said. They're not even reading. And the rest of its brief is predominantly dedicated to refuting the argument that the Second Amendment prohibits licensing requirements. But those arguments are red herrings with respect to California's urban open carry ban. This is a major F up on the California Democrats' part. Page 29 at the top. Baird may have argued, in addition, that any licensing requirement would be unconstitutional under the Second Amendment. But in his complaint and his briefing, he clearly contends that California's ban on open carry in the areas of the state where 95% of the people live is unconstitutional. What did they just say? In his complaint and his briefing, he clearly contends. So, in other words, it was clear. It's like a John MacArthur sermon over here. You know, he's always saying it's clear, it's crystal clear. I always thought, well, if it's so crystal clear, why would you have to say it's crystal clear? I mean, it would just be clear, right? Yeah, it's kind of the same thing here. It's like, well, yeah, I wouldn't have to say it was clear, except for you guys didn't frickin' read it. And that's probably why John MacArthur was always saying it's crystal clear, because you're not even reading the dadgum Bible. Good old Johann Sebastian MacArthur. Yeah, he clearly contends that California's ban on open carry in the areas of the state where 95% of the people live is unconstitutional. In other words, he's saying, I didn't waive that challenge. Finally, California's heavy reliance on racist or explicitly xenophobic laws. I love that he's just throwing that language right back in their face. That are supposedly analogous to California's current. No, no, Judge, they are analogous. You don't understand. They are analogous. It's just that they're not lawful authority, but they are analogous. Yeah, that's why they should be struck down. Uh, uh, Finally, California's heavy reliance on racist or explicitly xenophobic laws that are supposedly analogous. That's the argument the Democrats made. They made racist arguments. Man, that's amazing. To California's current open carry ban is misplaced. Such laws are a part of the history that the Constitution left behind. That's Kavanaugh's language in Rahimi at 723, and are thus not appropriate analogs in the Bruin inquiry. Letter A. A is in boy. Just kidding. A is in apple. Page 29. The loose analogizing California asks this court to conduct in connection with the nuanced approach, the nuanced. Oh, we are so nuanced. Guys, we are so nuanced up in this bitch. Oh my goodness. We're Californians and we are nuanced. And we are using racism and xenophobia. And we are so nuanced. And we're like ignoring basically what the plaintiff is saying. So, can you just like nuance the Second Amendment away? I would love if you nuanced it away. Thank you. Thank you. Believe all women, even though we can't define what a woman is. Okay, sorry. I don't know what happened. Spirit took over. I'm not sure what happened. I knew I needed to pray earlier. The loose analogizing California asks this court to conduct in connection with the nuanced approach is entirely inappropriate in this case. As explained above, both at the time of the founding, yeah, happy 250th and at the time of the 14th Amendment, the Republican 14th Amendment, yeah, adoption, there is a total absence of any historical practice of banning open carry. Yike! Yike! Yeah, you can't nuance that away. You're going to try, but you're going to fail. Nuance that. Quite the opposite. In antebellum Democrat America, well, I'm going to say because that was before the Civil War. At least most of the antebellum period was before the Civil War. Was Democrat, not Republican. Republicans started in 1854, so that's what, 6 years, something like that before secession. Quite the opposite. In antebellum America, it was clear that open carry was widely seen as entitled to special constitutional protection. And when there is a clear and unbroken historical tradition, it is impermissible to analogize at levels of generality so high that precisely what was recognized as protected may now be banned. And he's saying, see, by the way, Democrat Cass Sunstein on analogical reason in the Harvard Law Review. Wow, 1993, 106 volume, page 747. Wow. He's saying, Cass there is saying, explaining that when properly conducted, analogical reasoning produces principles that operate at a low or intermediate level of abstraction. Yet that is exactly what California asked this court to bless. Despite a clear historical tradition of protecting open carry and regulating only concealed carry, the district court, we're on page 30 at the top, concluded that California nonetheless may ban open carry for the simple reason that American governments have imposed restrictions on how people carry guns since the founding era. That is a paradigmatic example of extracting the supposedly governing constitutional principle at too high and too abstract a level. The fact that the extracted principle can be used to justify precisely the conduct that historically was consistently deemed protected should be a strong clue that a court has abstracted its governing principle at a level of generality that is much too high. Indeed, here it is hard to imagine any carry ban, including the sort of complete and total carry ban rejected in Bruin, that the principle extracted by the district court would fail to justify. That's a reductio ad absurdum if I've ever seen one. Using Cass Sunstein, of all people, an Obama official. Wow. A Democrat. Hmm. Republicans are using Dems against Dems. That's great. The district court may have been understandably led astray by cues from this court's recent Second Amendment cases employing a mode of analysis that abstracts a very generalized principle and then applies it. In these instances, the principle is so generalized that it seems to always cover the analogous conduct. That is what the district court did here. But what makes that approach still incorrect here, even accepting this circuit's Second Amendment precedents at face value, is that when the Ninth Circuit has applied the nuanced approach and analogized at such high levels of generality, it has been at least nominally predicated on the assumption that some circumstances have significantly changed. But here, nothing has changed. Open carry remains open carry just as it was at the founding, and concealed carry remains concealed carry just as it was in 1791. Nothing to add there. This is pretty good. Page 31 at the top. To get around that reality, the analogical argument that California would have us adopt really boils down to the idea that today a state can ban all open carry because some other states regulated some other things at the founding in some other ways. That is too sloppy a fit. Bruin requires a closer relationship between how and why a historical regulation burdened the right to bear arms and how and why a modern analog burdens that right. Yet by extracting a broad principle at such a high level of generality, California and the district court conclude that all open carry can be banned so long as some type of other carry, here concealed, is allowed. The historical record nowhere presents such a principle. As explained, the historical record clearly evinces that open carry was universally considered to be protected by the right to keep and bear arms, not just that some form of carry was protected. It is, of course, true that, as Heller and Bruin both recognized, the Second Amendment is not unlimited. In our history and tradition, certain firearms regulations have existed comfortably alongside the Second Amendment, like, for example, some restrictions on concealed carry. But although some restrictions were allowed, most were not. Under the approach California and the dissent want us to adopt today, however, as long as certain aspects of firearms carry were regulated and others were not, it hardly matters at all which historically were regulated. It hardly matters at all which historically were regulated. Once again, that is not faithful to Bruin's methodology, which requires a closer fit between the how and the why before a historical analog can be used to bless a modern day restriction on the right to bear arms. Let's take a look at footnote 18. I'm going to mute it for a sec. Yeah, I'm definitely going to I'm going to read footnote 18 for you. Indeed, at oral argument, California, that's the Democrats, candidly conceded yes when asked if the principle it was defending was essentially that it doesn't matter what areas are banned, they are kind of fungible. You can ban certain things as long as you allow dot 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 enough left. Enough. Well, what's enough? That's the interesting interest balancing. Going back to that, trying to get back to the First Amendment analog, um, which is inappropriate here. You know, the levels of scrutiny, back to scrutiny land, which is just made up. It's a bunch of made up crap. Oh, anyway, let's keep going. More pointedly, page 32 at the top, that the founders permitted restrictions on concealed carry but did not allow restrictions on open carry is not a license to ban carte blanche open carry, so long as concealed carry is, although tightly regulated, not entirely banned. In other words, if there were ever an instance where it is impermissible to use loose analogizing under the auspices of applying Ninth Circuit's nuanced approach, it is this case. If the nuanced approach can be properly applied here, where there is a clear and widely documented practice at the founding and at the time of the 14th Amendment, and that practice has remained unchanged from 1791 to now, then the quote nuanced approach, or so nuanced, unquote, exception has completely swallowed Bruin's rule, and there is no case where the default rule under Bruin would apply. That's, of course, exactly what they want. They want to be able to do whatever the hell they want to do in the name of public safety. Their concept of the police power when it comes to disarming innocent people and making them criminals, in their minds, is unlimited. Not to bring up health food, but let us continue. But that is not the law. Bruin envisioned that the nuanced approach would be the exception, not the rule. And the overwhelming historical consensus that open carry was protected both in 1791 and 1868 makes this case very much like Bruin. Wow. That's the that is very good quote right there. The overwhelming historical consensus that open carry was protected both in 1791 and 1868 makes this case very much like Bruin. Wow. Put that on a coffee mug. Gun violence is an issue that plainly existed at the founding, and yet open carry was never banned. And in Bruin, when the Supreme Court was confronted with a practice that was entirely unchanged from the founding, the ability to carry a firearm outside the home for self-defense, the court never so much as hinted that the nuanced approach was appropriate. Quite the opposite. The court held the government The court held the government to its burden of presenting a historical analog that curtailed the right to bear arms in an analogous manner and for an analogous reason. We're on page 33 at the top. Yeah. Given that the nuanced approach is inopposite in cases like this, which involve a clear practice dating back to the founding, it is doubly true that the nuanced approach cannot be wielded to ban the very conduct that was protected at the founding under the implicit principle that, quote, a lot can be banned as long as not everything is banned, unquote. The bottom line, when there is a clear and unbroken historical tradition, it is not permissible to analogize at levels of generality so high that it becomes impermissible to ban what was protected so long as the government refrains from outright banning some other practice that could have been prohibited. All right. We're in letter B as in apple. JK. B is in dog. JK again. I'm serious now. B is in boy. I'm pausing to get the last droplets of coffee that have some semblance of warmth out so that I can finish this thing. Give me a sec. All right, I'm back. The state suggests that we can ignore the tremendous evidence of a tradition of open carry dating back to the founding because Baird is only challenging a licensing regime. But that is inaccurate. That is inaccurate. California's legal regime is a complete ban on open carry in urban areas, the areas of the state where 95% of the people live. A licensing regime that entirely bans open carry in all the areas of the state where 95% of the population reside is a ban on open carry in those areas, theoretical exceptions notwithstanding. If a state by state if a state by statute categorically banned driver's licenses for 95% of the state's drivers or for 95% of the roads in the state, I should add public roads, it would be quite strange to characterize that as a mere licensing regime. We would have no trouble recognizing such a characterization as classic Orwellian doublespeak. Amen, bro. Accordingly, California's affirmative argument regarding the history and tradition of licensing regimes is irrelevant to this case because Baird alleges that he wants to be able to open carry in areas of the state where 95% of the people live, the areas where California flatly bans open carry, licensed or unlicensed, this evidence, regardless of whatever its force might be otherwise, is inopposite. And California has put forth no meaningful evidence that a ban on open carry is consistent with any of our nation's history or traditions. Indeed, California scarcely even attempts to put forth any such evidence, despite having had multiple chances to satisfy its burden. You see, you guys, just take a look at this paragraph. And take a look at it. I'll read it again for those on audio only. I want you to take a moment and really think about this. Let this sink in, okay? Guys, listen to me. You got to let this sink in because there's some stuff here that you need to let sink in. My notes here, as you can see, you see this? I make notes, right? I print it out. You see? You hear this? You hear this like Rush Limbaugh used to do? He's got paper in his hand. Look at my notes here. I have a PhD in this stuff. Spent 11 years working on a PhD in public law and American politics. I did my dissertation on constitutional law, including a close look at the Second Amendment, constitutional jurisprudence at the D.C. Circuit. This is my comment here. The balls of these Democrats. That's my technical analysis of this paragraph right here at the top. Page 30, what is it, 34? The balls of these Democrats. This is not headline news when the legacy media are Democrats. But the balls of these Democrats, look at this. California has put forth, I mean, just let this sink in, folks. Let this sink in. And California has put forth no meaningful evidence. Let that sink in. They don't think they owe you any evidence. They don't owe you an explanation for what they want to do to you. They want to criminalize you for innocent conduct. And they don't believe they owe you a shred of evidence before they do so. The balls of these Democrats. And you know what, guys? I spent 20 years on the campuses, 12 campuses. 7 of them, most of them, government campuses run entirely by Democrats. You want me to list them out for you? I can list out I'm building up to something. You guys, I have street cred. I've designed and taught 190 college courses over that time. 190 on 12 campuses, most of which were Democrat-run government campuses, and some of which were Democrat-run private campuses, like Loyola Marymount University, where I was for 10 years. I was also at Biola for 1 year, and I think that Republicans run Biola, but they're a bunch of wussies, and they have other problems. We're not going to get to that. These Democrats just think they have a right to rule you and without explanation. Generally, it's not this obvious because it's done by kind of a committee kind of a deal where the personal responsibility is virtually non-existent. But this Republican judge is noting that California has put forth no meaningful evidence that a ban on open carry is consistent with any of our nation's history or traditions. I mean, the Democrats here are using Democrat KKK stuff because that's all they could come up with. Indeed, California scarcely even attempts to put forth any such evidence, despite having had multiple chances to satisfy its burden. It's like, you know what it reminds me of? Excuses that I would get in the classroom for why work was late. And you give this person plenty of opportunities to turn in more work, and they don't. It's and they expect it, they expect a passing grade. It's like it's total Democrat grade inflation, I'm telling you. In any event, for the reasons explained above, a historical tradition permitting the banning of open carry finds no support in the historical record. It is hard, if not impossible, to find any practice associated with the carriage of firearms that received more explicit constitutional protection under the Second Amendment in the 19th century than open carry. Wow. Accordingly, it is perhaps unsurprising that the en banc Ninth Circuit has already recognized the primacy of open carry. In a pre-Bruin case, when the constitutional status of public carry was still being debated, this court explained that, quote, if there is such a right to public carry, it is a right to carry a firearm openly, unquote. That's in Peruta versus City of San Diego, 824. The third series of the Federal Reporter at page 942. That's 2016. The en banc Ninth Circuit was correct. That was the en banc panel that overturned the three-judge panel from 2014. The en banc panel was 2016. That was rejected by Bruin, 597 U.S. at page 1. And Bruin has since laid to rest the antecedent question. There is clearly a constitutional right to publicly carry firearms. I would think that that's pretty obvious. Jeez. And as our court has already declared, that entails a right to carry a firearm openly. That's a very good use of Ninth Circuit precedent. Nice job. He just used the Democrats against themselves on his own circuit. That was really good. This guy's really good. This guy. What's his name? Van Dyke. He's really good. California's urban open carry ban that flatly prohibits all open carry in the areas of the state where 95% of the people live is thus unconstitutional. Letter C, and we're on page 35 at the top. C is in.
Oh, don't do it. Don't do the fake one again. Don't do it.
C is in elephant.
Huh?
C is in cat. California briefly addresses some regulations regarding the manner of open carry, but these arguments also fail. As a threshold matter, as described above, there are very few laws from the founding that regulated the manner of public carry, and no direct statutory bans on the carry of firearms. California attempts to circumvent this history by analogizing to affray laws, but those are not proper analogs here because the how and why of those historical laws do not match California's ban. Affray laws have their root in the English Statute of Northampton, which was passed in 1328 and prohibited bringing forth in a fray of the peace. Affray was originally understood as the fighting of two or more persons in some public place to the terror of his majesty's subjects. That's from Blackstone's commentaries. Okay. But As applied to weapons, an affray was typically understood to encompass the offense of arming oneself to the terror of the people. And he's quoting Rahimi. Well, he's referring to Rahimi, I should say. Okay, and Blackstone. From this, it is clear that the why of an affray law was to combat the misuse of firearms in particular cases where physical violence was likely. Now, this is a really important point. It was to combat the misuse of firearms. Now, what can we say about this? The Democrats think that any use of a firearm is a misuse of a firearm. You see, that's the problem. That's the problem that you're trying to untangle from them. You're trying to get them to see that no, mere possession is not misuse. Mere bearing is not misuse. Mere keeping is not misuse. Mere purchasing is not misuse. Mere selling is not misuse. They want to make everything related to firearms misuse. But there was a clear distinction between use and misuse, between keeping and misuse, between bearing and misuse, between building and misuse, between selling and misuse, between buying and misuse. And that's the work we're doing on a cultural level is getting that distinction back in there. Okay? Firearms are normal. And there's a political effort on the part of the Democrats to make firearms weird, to where the mere mention of a firearm is to evoke misuse in your mind. Now, think about the term gunman. Think about the term active shooter. You've heard these terms, right? That is to, I don't like those terms because it's part of this political tradition of merely the thought of a firearm evokes the thought of misuse, right? Gunman. I mean, all you're doing is mentioning the object and putting it in front of the word man, and what is evoked? Misuse, right? That's the rhetorical strategy though. So every time you use the term gunman, you're you're buying right into this whole banning Democrat propaganda crap. Every time you use the term active shooter, the same thing. Every lawful uh, use of a firearm, which results in a discharge or which involves a firearm discharge, is shooting, right? Right? Think about going to the firearm range. That's lawful. And what do people do at a firearm range? They're shooting. It's lawful. It's not misuse. It's lawful. It's moral. You're training for self-defense. You're training for recreation. These are lawful activities. And yet, when attempted murder is happening, which is a crime, it's a crime going back to the Ten Commandments. Hello? Hello? It's a paradigmatic historical crime. It wasn't invented yesterday. It's not like these paperwork crimes that the ATF invents. This is a historical pedigree of thousands of years. Murder is wrong. It's crime. And instead of using the word murder or attempted murder, what do we use? Shooting, which is not a crime. Crimes might involve shooting, but per se, it's not a crime. Just like crimes might involve walking, crimes might involve a screwdriver. But when I go to Ace Hardware and I say, "Hey, I need a Phillips head screwdriver," they don't go, "What are you going to do with it?" You see, active shooting. There's active shooting happening at the firing range. It's active and it's shooting. It's not misuse. So why are we using these terms that go right into the cultural agenda of these tyrants, where they're trying to collapse the moral and lawful use of firearm, keeping, bearing, carrying, presenting, um, cleaning, storing, selling, buying, building, all of these lawful activities, perfectly moral, lawful activities, including training, which involves shooting. Why in the world would you use the same verb for paradigmatically horrific criminal activity? You have to distinguish and disentangle in the public's mind misuse from use. And you shouldn't use the same verbs. You shouldn't use the same nouns. Don't use the word gunman when the guys who are responding lawfully to that are also gunmen. Hello? Hello? This isn't Andy Griffith here. Okay? You guys don't know what I'm talking about with Andy Griffith. He didn't carry a gun. The police officers, they carry guns, dude. They're gunmen. Don't use the word. That makes no sense to pick an object, stick it on the front of man, and then now it's a crime. That makes no sense, especially when the non-criminals are responding and they have the same description. And you talk about the police. Let's put the police aside one side. I'm talking about lawful interaction with a crime to stop a crime. In California, the California Penal Code specifically carves out an exception for public carry in an emergency when, under a reasonable person standard, uh, there's a threat to a great bodily injury or life uh, endangering threat to yourself or another person. It's lawful, and there's a good pedigree for that. It's moral too. It's moral. Shouldn't be punished for taking arms into your own hands to stop an imminent threat. So don't use this term gunman anymore. It's not a good term. In the present crisis, when we have so much grade inflation, such a short attention span, people just they can't distinguish between use and misuse. Be careful there. I hope you're listening to what I'm saying. I probably should reference an article I did called Two Types of Self-Defense. I think I will um, go ahead and throw this up there if I can find it. There we go. Yeah, I got it. All right, let me just show you how I got to it, okay? Um, so I Google searched two types of self-defense. The AI was totally wrong. Let's scroll down. Krav Maga, Wikipedia, right here. You see this gun owner's radio? You see this? April 9th, 2020. I wrote that for gun owners radio. Okay. Should still have my name on there unless they stole the copyright. Okay, it says Michael Schwartz, but he did not write it. I wrote it. There it is. There's my name right there by Lucas J. Mather. Okay, good. Michael, I was going to be pissed at you if you took my name off that, bub. So there it is. Gun owners radio, two types of self-defense. There are two types of self-defense in the present crisis. That's because there are two types of threats to your well-being. The first kind of threat is criminal in the old-fashioned sense. I don't mean the new kinds of criminals that are invented by bureaucrats and politicians who create laws that criminalize previously and truly immoral, truly innocent conduct. I mean bad people who are physically dangerous. So the first kind of self-defense, first, the most obvious perhaps is self-defense against the evil person who would wish to do you or your family, your friends physical harm by causing serious injury or death. The second type of self-defense is against the state, against the social and legal and political community who would, in the name of and under the guise of law, deprive you of your right to the first kind of self-defense. So I urge you to be careful in the language that you use. Okay. Actually, I was thinking of a different article that I wrote for them. Um, I actually made a different argument based on the language. And I'm going to have to find, I can't remember the title of it, so I don't want to take too much time here, but I just thought I would um, point that out. Okay. That resource for you. Okay. I've been writing about this for a while and thinking about it and debating about it and stuff like that. Okay. Let's get back to the text of Baird versus Bonta. Now, from this, it is clear that the why of an affray law was to combat the misuse of arms in particular cases where physical violence was likely, and the how was by disarming specific individuals in discrete cases when they, and they only, were already committing criminal acts. I like how he's putting this. They were already committing criminal acts with a firearm, and in doing so, demonstrating that they were misusing their firearms in such a manner as to incite violence. So, criminal acts. There's really two types of criminal sense of criminal we mean. We mean criminal in the old-fashioned sense, which it's really wrong. It really should be crime in the positive law. In other words, the natural law would regard that as criminal. And then criminal in the sense of it's a paperwork crime that some bureaucrat and regulator made up, and or the legislature made it up because they were too hasty in drafting something and they criminalized innocent conduct. So it's a crime on paper, but in reality, it's not really a crime. It's not crime by the natural law. And the natural law is our judge. It's our judge of conscience over the positive law. Okay. Now, let's go to page 36. Thus, affray laws might be more properly analogized to modern laws that criminalize the brandishing of firearms or otherwise using a firearm in a way that is criminal, like truly criminal, like Ten Commandments kind of a criminal, and enforcing that prescription with disarmament. Okay. Um, okay. That is plainly not analogous to California's ban on openly carrying a firearm lawfully and peacefully in the areas of the state where 95% of the population resides. We're on page 36. California's attempt to analogize its open carry ban to historical affray laws is very much like trying to justify a new complete ban on speech in public areas by pointing to a historical prohibition on fighting words. Very good. If you're going to analogize to the First Amendment, that's a pretty good analogy. Not bad. Okay. Perhaps implicitly recognizing that How and why it's banned Byrd and Second Amendment right is not the same as how and why carry restrictions. In 1791 and 1868 burdened the Second Amendment right. California retreats to quasi-interest balancing by arguing that regardless of how and why its ban imposes only a minimal burden on Baird's Second Amendment right. This argument fails too. Yeah. Um, this argument fails too. As explained above, in our nation's history and tradition, open carry was widely recognized as being central to the Second Amendment right. Footnote 19. Indeed, the district court also recognized that affray laws are more properly analogized to modern laws against brandishing, thus appearing to implicitly concede that affray laws are therefore likely inopposite analogs for an open carry ban. Very good. See what I'm saying? Do you see the point I was making earlier about distinguishing misuse from use and the political agenda of making mere usage misuse in the Democrat mind? That's their agenda. Any misuse, any use is misuse by definition. Why? Because guns are bad. I mean, just think about the when you're watching television or something like that, and someone goes, "Oh my gosh, he's got a gun." Well, that would apply to anybody open carrying. You see the distinction. The distinction is flattened between use and misuse. If merely carrying evokes the "oh my gosh, he's got a gun" in the term of misuse, that distinction is collapsed and the Democrats win. Why would you freak out that somebody has a gun just because they have a gun, unless you're so used to hearing the term gunman to be a bad person, except for when they're the police? Well, the police are not always around, you know. Hello, hello. If they were always around, we wouldn't have murders, right? And well, first of all, think of it this. If, if the police are moral, let's just grant that. They're moral, they're effective, and let's say they're moral, effective, and they're always around. Well, then why is there crime? They're not all let's just take for granted that they're moral and effective, which you can really question that. And anybody who watched the George Floyd thing and you're not questioning that, okay, fine. You do you. You go over there. I don't personally think that when the police kill a person in custody, um, that that the proper response is burning down private businesses. That's me, you know. But you do you. Um, but let's just take it for granted that the police are moral and effective. Okay, they're not always around. And there are other people that have been trained and are moral and effective, and they are around. These are your options.
Oh, that's just because Republicans.
Well, you can complain about it all you want. The Republicans put guns in the hands of black people. That's why there's no slavery. So you realize that you're arguing against the very thing that banned slavery. You realize that, right? When I ask my students, I say, "Hey, guys, you for slavery?"
No.
Okay. If the slaves had guns, would there have been slavery? Republicans put guns into the hands of black people. That's why there's no slavery. Democrats tried to take guns back out of the hands of black people, and they were doing it. They're still doing it, but they were doing it even more obviously, even in 2010. The city of Chicago versus Otis McDonald. McDonald versus Chicago. They spent millions of dollars to take a gun away from a black man during Obama's presidency. I mean, it's no wonder that so-called Black Lives Matter started during Obama's presidency. I mean, they might have been onto something initially, maybe. I don't know. Uh, it's certainly true. I mean, Republicans have been saying that for a long time. Hello? Good Lord. All right, let's get through this, guys. Perhaps implicitly recognizing that how and why it's banned Burden's Second Amendment right is not the same as how and why carry restrictions in 1791 and 1868 burden the Second Amendment right, California retreats to quasi-interest balancing by arguing that regardless of how and why, its ban imposes only a minimal burden on Baird's Second Amendment rights. This argument fails too. Yeah. As explained above, in our nation's history and tradition, open carry was widely recognized as being central to the Second Amendment right. A ban on that which is at the core of the Second Amendment is not a minimal burden on the Second Amendment right. And in any event, the Supreme Court has already rejected interest balancing as a permissible approach to interpreting the Second Amendment. See generally Bruin 597 US at page 1. We're on the top of page 37. We're right at the cusp of D. And I'm being serious here. I'm not joking anymore. Okay. All right. Because I want to get this done. D is in dog. Yes. Okay. D is in dog. So that's where we're done for today. I didn't finish footnote 19. I'm going to go back up to the previous page and reread footnote 19. Indeed, the district court also recognizes that fray laws are more properly analyzed to modern laws against brandishing, which is a crime, is usually treated as a crime. That's displaying the handgun in a criminally threatening manner. I mean, in other words, in furtherance of some other crime, for example, assault, um, not self-defense. Okay. I don't usually like the word assault either because there's lawful activity that's typically called assault. For example, the police have assault teams, SAWT. SAWT. No, there's an A in there. SWAT. SWAT. Right? Special Weapons Assault Team, right? Special Weapons and Tactics, but they're typically called assault teams, right? And it's not meant in a criminal sense there. So I don't like the word assault because it's ambiguous. The same word, same spelling can be criminal, non-criminal. It can be paradigmatically criminal. It could be paradigmatically not criminal. Okay. So I think you got to be really careful about your language, but this word brandishing is typically meant a crime. Okay. Not merely displaying for self-defense. That wouldn't be really what we mean in the technical search by brandishing. Brandishing would be um, where it's in furtherance of another crime like robbery, um, armed robbery, rape, um, kidnapping, so on and so forth, vandalism, arson, right? You display a firearm so that you keep people away from you while you're trying to burn down a building. Okay, so um, now state and colonial governments did not allow people to carry firearms in ways that intimidated or suggested evil purposes. See that's a key issue, the word evil. These older statutes always put moral terms into them to help you. So there was a lot more clarity back then than there is now. There's so much grade inflation and so much secularization that's occurred that hasn't really done us very many favors. Brandishing and display prohibitions, laws patterned on the statute of Northampton, and prohibitions on firearms in large groups are examples from this category. All right. All right. Well, we're going to get to D next time. Thanks for joining me on the Republican Professor podcast. I've been your host, Dr. Lucas J. Mather. Today is 17 April 2026, years after Jesus. It's a Friday. God bless you guys. Hang in there. We'll see you next time.